Alright, what do we got here? Okay. Actually, this music doesn't seem appropriate right now. Seems a little weird. Okay. Not only did the United States neglect to confer with the victims before... How do I fucking... That thing is too stiff. Not only did the United States neglect to confer with the victims before it entered into the agreement with Epstein, it also failed to notify them of its existence for at least 9 months. The United States sent post-agreement letters to the victims reporting that the case is currently under investigation, explaining that this can be a lengthy process and we request your continued patience while we conduct a thorough investigation. In June 2008, and that's after they already made the negotiations, right? And in June 2008, the United States asked the victims to explain why federal charges should be brought against Epstein without mentioning the agreement to them. That is wild. That's kind of nutty. That's kind of nutty. Why? I need to get an answer for that. On June 27, 2008, the United States informed the victims that Epstein planned to plead guilty to the Florida charges 3 days later on June 30, 2008. But the United States failed to disclose that Epstein's pleas to those state charges arose from his federal non-prosecution agreement and that the pleas would bar a federal prosecution. The victims did not attend the state court proceedings. On July 7, 2008, Jane Doe No. 1 filed a petition alleging that she was a victim of federal crimes committed by Epstein involving sex trafficking of children by fraud and enticement. By fraud and enticing a minor to commit prostitution, and that the United States had wrongfully excluded her from plea negotiations and violated the Crime Victims' Rights Act, USC 3771. Recommend using 6800 kbps. Whatever. She alleged the United States violated her right to confer with federal prosecutors, her right to be treated with fairness, her right to receive timely notice of relevant court proceedings, and her right to receive information about restitution. The United States answered that it used its best efforts to comply with the rights afforded to victims under the Act, but that the Act did not apply to pre-indictment negotiations with potential federal defendants. How do you have a I need a lawyer. How do you have a pre-indictment negotiation if you're doing a plea deal? How do you do a plea deal before the indictment? That's very confusing. That's very confusing. The United States entered negotiation with potential federal defendants. After Jane Doe No. 2 joined the initial petition, the district court found that both women qualified as crime victims under Act 18 USC 3771. Among other relief, the victims sought rescission of the non-prosecution agreement, which makes sense. The victims' petition remained dormant for years while they pursued a federal civil suit against Epstein and reached a settlement agreement with him. I hope I get to read that. Let's see. Pretty wild. Pretty wild. As a basis for relief against Epstein in the civil suit, the victims relied on Epstein's waiver of his rights to contest liability in the non-prosecution agreement. As a basis for relief in the civil suit, what they got in the civil suit, the victims relied on Epstein's waiver. Epstein waived his right to contest liability in the non-prosecution agreement. So he could still be liable, like civilly, even though there's a non-prosecution agreement. That's such difficult language to understand. Over Epstein's objection, the district court in that civil suit ordered the United States to produce the documents given to Epstein's attorneys during his plea negotiations. The victims received correspondence written by the United States, but they never received any correspondence written by Epstein's attorneys during the plea negotiation with the United States. So even though they were ordered to get stuff, they didn't get stuff. What the fuck? In 2011, the victims renewed the prosecution of their petition against the United States. The victims moved to use correspondence between the United States and Epstein's attorneys during the plea negotiations to prove violations of their rights under the Act. And the victims later moved the district court to compel the United States to produce all requested discovery about the plea negotiations. That's cool. Did it work? Epstein and his criminal defense attorney Roy Black and Martin Weinberg moved to intervene for the limited purpose. That's what we're reading now. Okay, got it. Got it. Epstein and his criminal defense attorney Roy Black and Martin Weinberg moved to intervene for the limited purpose of challenging the disclosure and use of the correspondence they wrote during plea negotiations. Right. After the district court granted their permissive intervention, the interveners moved for protective orders. The interveners argued that the work product privilege protects their correspondence, that Federal Rule of Evidence 410 and Federal Rule of Criminal Procedure 11 create a privilege for plea negotiations, and that their correspondence contained confidential grand jury material. They also argued the district court to recognize a common law privilege for plea negotiations. The United States responded that the court should consider the correspondence privilege, but that it would disclose the correspondence if the court ordered it to do so. Epstein later filed two other motions to intervene in a limited capacity, one to challenge the disclosure of grand jury materials and another to challenge any remedy that would violate constitutional and contractual rights under the non-prosecution agreement. So are plea deals usually like totally sealed away? No one ever knows what's in a plea deal? I guess that makes sense, because if you could find what was in a plea deal, people would know. Huh. Okay. The attorney interveners did not join either of these motions. The district court has not yet ruled on Epstein's motion to intervene to prevent disclosure of grand jury materials, but this district court has allowed him to intervene with regard to any remedy issue concerning the non-prosecution agreement. It's kind of wild. District court then issued two discovery orders, both of which the interveners challenged in this appeal. In the first, the district court denied the intervener's motion for protective orders and granted the victims the right to proffer. What does proffer mean? To hold out to someone for acceptance, to offer. Why not just use the word offer? Granted the victims the right to offer the correspondence between the United States and Epstein's attorneys, but the district court reserved ruling on the relevance or admissibility of any of the correspondence to prove violations of the Act. In the second, the district court required the United States to file answers to all outstanding requests for admissions and to produce documents in response to the requests for production by the victims, including any documentary material exchanged by or between the federal government and persons or entities outside the federal government, including, without limitation, all correspondence generated by or between the federal government and Epstein attorneys. One thing I hate about these fucking documents is they use run-on sentences and they stuff every possible detail into every sentence, where it's really confusing. After the interveners filed this interlocutory appeal, the victims moved to dismiss the appeal for lack of jurisdiction. This court later entered a stay of the second order, which required the United States to disclose the correspondence to the victims. What is a stay of an order? Stay is an action taken by a court to stop a legal proceeding or the actions of a party. This court later entered a stay of the second order. After the interveners filed this interlocutory appeal, the victims moved to dismiss the appeal. The court later entered a stay of the second order, which required the United States to disclose the correspondence to the victims. Why? Why? Two standards of review. Two standards of review govern the issues in this appeal. We review de novo whether we have jurisdiction to decide this interlocutory appeal before addressing the merits. We also review de novo the interpretation of the federal rules of evidence. See United States v. Campa, etc. Case law. And the issue of whether to recognize a privilege under Federal Rule of Evidence 501 is a mixed question of law and fact that we review de novo. Adkins, what is de novo? What is de novo in law? De novo is a Latin term that means again, or from the beginning, or afresh. When a court hears a case de novo, it is deciding the issues without reference to any legal conclusion or assumption made by the previous court. That's interesting. That's new. Okay, I like that. One sec, I need to fucking Zemo real quick. All right. But we review for clear error factual findings made. By a district court. Morissette Brown versus Mobile Infirmary Medical, etc. Discussion. We divide our discussion into two parts. First, we explain that we have jurisdiction over the interlocutory appeal by limited interveners who, as claimants of a privilege, challenge a disclosure order directed at the United States, a disinterested party. The United States is a disinterested party. Second, we explain that the plea negotiations are not privileged from disclosure. Let me nail that down again. Okay. First, we explain that we do have jurisdiction. Second, we explain that the plea negotiations are not privileged from disclosure. Got it. A, we have jurisdiction to decide this interlocutory appeal. The victims argue that we should dismiss this appeal for lack of jurisdiction for two reasons. First, they argue that the Perlman Doctrine, which permits a claimant of a privilege to appeal a non-final judgment, applies only to grand jury subpoenas. Perlman v. United States. Second, they argue that a decision of the Supreme Court, Mohawk Industries, forecloses as interlocutory appeal of a denial of a claim of privilege. I can't even begin to understand that part. The courts of appeal have jurisdiction of appeals from all final decisions of the district courts of the United States, except where a direct review may be had in the Supreme Court. A final decision is one by which a district court disassociates itself from the case and ends the litigation on the merits and leaves nothing more for the court to do but to execute the judgment. Discovery orders are ordinarily not final orders that are immediately appealable. 5 notable exceptions to this rule exist: the Perlman Doctrine, the Collateral Order Doctrine, which I just read about earlier, a certification provided by a statute, a petition for a writ of mandamus. I'm going to guess that you're forced to comply with a mandamus, or an appeal of a contempt citation. The Perlman Doctrine allows an intervener to file an interlocutory appeal of an order denying a motion to quash a grand jury subpoena. Allows an intervener to file an interlocutory appeal of an order denying a motion to quash a grand jury subpoena. But is discovery a fucking grand jury subpoena? I don't think it is. This exception derived from Perlman v. United States permits an order denying a motion to quash to be considered final as to the injured third party who is otherwise powerless to prevent the revelation. At 558, quoting in grand jury proceedings. Under Perlman, a discovery order directed at a disinterested third party is treated as an immediately appealable final order because the third party presumably lacks a sufficient stake in the proceeding to risk contempt by refusing compliance. The Perlman exception is relevant only to appeals brought by the holder of a privilege where the disputed subpoena is directed at someone else. Okay, but it's directed at themselves because they're asking for their own discovery. We have exercised jurisdiction under the Perlman Doctrine when the party ordered to disclose the information has no direct and personal interest in the suppression of the information and would be reluctant to risk a contempt citation such that the order is definitely final as to the complaint of the privilege. We have not invoked the Perlman Doctrine to exercise jurisdiction over an interlocutory appeal outside the context of a grand jury proceeding, but we have exercised jurisdiction over interlocutory appeals by claimants of a privilege in some civil proceedings. This person exercising jurisdiction because the appellant claims a privilege of non-disclosure relating to materials that another party has been directed to produce. Holding that an order compelling production of allegedly privileged material is immediately appealable because the privilege holder has no power to compel the custodian of the material to risk a contempt citation for his refusal to comply. That's like so many layers of liability. Perlman in a civil action to recover, exercising interlocutory jurisdiction and citing Perlman in a civil action to recover damages for breach of a bond against a surety company where denial of the privilege could not be reviewed on appeal either from the final judgment or from a contempt order. The victims argue that we should not extend Perlman beyond an intervener's appeal of a grand jury subpoena, but we decline to draw an arbitrary line. The victim's argument has an ipse dixit quality. What the fuck is ipse dixit? Ipse dixit, dogmatic or unproven statement. The victim's argument has a dogmatic or unproven statement quality. That is, because our court has never before applied the Perlman doctrine outside of the grand jury context, we should not do so now. But we must ask instead whether applying the doctrine here makes sense. I don't think it does, because you're supposed to be hyper-autistic about this stuff in law, but what do I know? The logic of the Perlman doctrine. I don't even know who's fucking speaking right now. Who's speaking right now? United States for the 11th Circuit, D.C. docket, Jane Doe versus United States of America, Roy Black. Appeals for the United States before Pryor and Martin, Circuit Judge, etc. Honorable Pryor, Circuit Judge. Okay, the Circuit Judge wants to extend the Perlman, but why? That's weird. If he extends the Perlman, then he says that he does have jurisdiction. Got it. Allows an intervener to file an interlocutory appeal of an order denying a motion to quash a grand jury subpoena. Strange. I'm not a lawyer enough. The victims argue that we should not extend Perlman beyond an intervener's appeal of a grand jury subpoena, but we decline to draw an arbitrary line. The victim's argument has an ipse dixit quality, which means that it is unsupported. That is because our court has never before applied, what's the word? Dogmatic. Has never before applied the Perlman doctrine outside of the grand jury context, we should not do so now, but we must ask instead whether applying the doctrine here makes sense. The logic of the Perlman doctrine applies with equal force in this appeal. Like a claimant objecting to a grand jury subpoena cannot challenge an indictment to remedy the disclosure of his privileged information, the interveners cannot challenge a final judgment in this proceeding to remedy the disclosure of the plea negotiations and the victim's petition. So hold on. Like a claimant objecting to a grand jury subpoena cannot challenge an indictment to remedy the disclosure of his privileged information. That's the Perlman. The interveners cannot challenge a final judgment in this proceeding to remedy the disclosure of their plea negotiations. So they're applying Perlman here, which is potential. And the victim's petition, like a grand jury proceeding, is ancillary to a criminal investigation. That makes sense. Read about that in... what was it? Some other doctrine. The rights and remedies provided by the act arise in a criminal prosecution and affect how the United States prosecutes that action. See below. The victims argue that Epstein has made himself an ordinary litigant through his intervention, but we disagree. The district court has allowed Epstein's attorneys to intervene only to contest the disclosure of their correspondence, and the district court has granted Epstein limited intervention to challenge only the disclosure of his attorney's correspondence and any remedy that involves the non-prosecution agreement. It's still fucking shocking to me you got a non-prosecution agreement. Epstein's only opportunity to challenge the disclosure order is now because there will not be an adverse judgment against him or his attorneys. The district court instead will enter any judgment against either the victims or the United States. And even if the victims succeed in their petition to rescind the non-prosecution agreement, Epstein can challenge only that remedy, not the judgment against the United States. The victims intend to use the correspondence from Epstein's attorneys to prove the United States violated the act, which is an issue separate from the kind of relief necessary to remedy that violation. It is all the more likely that the district court would fashion a remedy that does not involve the non-prosecution agreement. If the district court were to conclude that rescission is unavailable, which might then bar an appeal by Epstein of that remedy. All right, I don't care about jurisdiction anymore. I don't care about jurisdiction. I don't care about jurisdiction. B. The intervener's correspondence is not privileged. The interveners argue that the district court erred when it ordered the disclosure of the plea negotiations because three privileges protect the correspondence. Rule of Evidence 410, the work product privilege of attorneys, and a common law privilege for plea negotiations in criminal proceedings. We disagree. No privilege prevents the disclosure of the plea negotiations. Federal Rule of Evidence 410 provides no privilege for plea negotiations. Federal Rule of Evidence 410 does not protect against the discoverability of plea negotiations, and even if it did, Epstein clearly falls outside his protection because he entered a guilty plea, and the victims intend to use the correspondence against the United States, not against Epstein. So I guess the reason why you don't, so that rule protects you from using correspondence against the initial person, but not a privilege of non-disclosure as the interveners assert. The text of Rule 410 unambiguously states that the evidence is not admissible against the defendant who made the plea or participated in the plea discussions, if the guilty plea was later withdrawn or did not result in a guilty plea. 410 governs, and it didn't because he got a, wait, it did. I don't know. 410 covers the admissibility of plea negotiations, not discoverability of them. Admissibility. They should be discoverable, just not admissible as evidence. Moreover, Epstein cannot invoke Rule 410 because he pleaded guilty to state charges based on the same conduct and has not withdrawn those pleas. The victims intend to admit the correspondence to prove violations of the act allegedly committed by the United States, not against Epstein. And even if rescission of the non-prosecution agreement about Epstein's interest, the purpose of the admission does not change. Rule 410 does not bar disclosure of the correspondence written by the attorney interveners. 2. Interveners waived any work product privilege. The interveners next contend that the correspondence falls under the work product privilege, but the finding of the district court that the interveners waived any privilege when they voluntarily sent the correspondence to the United States during the plea negotiations is not clearly erroneous. Disclosure of work product materials to an adversary waives the work product privilege. Boom! Get dunked on. Even if I'm learning a lot, actually. Even if it shared the common goal of reaching a quick settlement, the United States was undoubtedly adverse to Epstein during its investigation of him for federal offenses, and the interveners' disclosure of their work product waived any claim of the privilege. As a last-stage effort, the interveners contend that if more is needed in addition to the plain language of Rule 410 to preclude disclosure of the correspondence to plaintiffs, it can be found in the conjunction of Rule 410, the work product privilege, and the Sixth Amendment right to effective assistance of counsel in the plea bargaining process. Now I just learned something about the Sixth Amendment. But this novel argument fails too, as explained above. Rule 410 does not create a privilege, and the interveners waived any work product privilege. The interveners concede, too, that the right to counsel under the Sixth Amendment had not yet attached when the correspondence was exchanged. The Sixth Amendment right to counsel ordinarily does not arise until there is a formal commitment by the government to prosecute such a formal charge, preliminary hearing, indictment, information, or arraignment. The conjunctive power of three false claims of privilege does not rescue the correspondence from disclosure. One thing I don't get, though, is Epstein, they gave him a federal non-prosecution agreement so that he would plead guilty to charges in Florida? Why? I don't get it. I don't get it. We decline to recognize a common law privilege for plea negotiations. The interveners also invite us to recognize a common law privilege for plea negotiations. But we decline to do so. The interveners have not established a compelling justification to prevent the discovery of plea negotiations in criminal proceedings. Although Congress empowered the federal courts through Rule 501 to continue the evolutionary development of testimonial privileges, we disfavor newly minted privileges which contravene the fundamental principle that the public has a right to every man's evidence. Accordingly, there's a presumption against privileges which may only be overcome when it would achieve a public good transcending the normally predominant principle of utilizing all rational means for ascertaining truth. Supreme Court has identified several considerations relevant to whether a court should recognize an evidentiary privilege, the needs of the public, whether the privilege is rooted in the imperative for confidence and trust, the evidentiary benefit of the denial of the privilege, and any consensus among the states. But none of these considerations weighs in favor of recognizing a new privilege to prevent discovery of the plea negotiations. Although plea negotiations are vital to the functioning of the criminal justice system, a prosecutor and target of a criminal investigation do not enjoy a relationship of confidence and trust when they negotiate. Their adversarial relationship, unlike the confidential relationship of a doctor and a patient or attorney and a client, warrants no privilege beyond the terms of Rule 410. Okay, that's fine. Wait, is that all there is? We affirm the disclosure order and lift the stay of order compelling the United States to disclose the correspondence. So all this is the so much reading. So much reading, and all I found was that they removed the stay order on the correspondence for the plea negotiations. What the fuck? Okay, let me add that. Lifted the stay on the order to provide the correspondence of the plea negotiations. Weird. So weird. Cool. All right, Jane Doe 1 and 2. Wait. When is this? 10/3, October 2008. The last one we read was June 2008. Right? All right, let's see what this one's about. Jane Doe, aka Jane Doe number 1, plaintiff versus Jeffrey Epstein. Opinion and order. Remanding case to state court. Jane Doe filed a 4-count complaint in the Circuit Court of the 15th Judicial Circuit in and for Palm Beach County, Florida, on June 25, 2008, bringing actions for sexual assault against Jeffrey Epstein and civil conspiracy, intentional infliction of emotional distress, and civil remedy for violation of Florida statutes 772, etc. The facts as alleged in the complaint are as follows. At all relevant times, Epstein was an adult male. Epstein engaged in a plan, scheme, or enterprise in which he gained access to primarily economically disadvantaged minor girls in his home, sexually assaulted these girls and coerced or attempted to coerce them to engage in prostitution, and then gave them money. In or about 2005, plaintiff, then 14 years old, became a victim of this scheme. Defendants Sarah Kellen and Haley Robson recruited girls ostensibly to give a wealthy man a massage for monetary compensation in his Palm Beach mansion. Under the plan, Robson was contacted shortly before and soon after Epstein was at his Palm Beach residence. Epstein, Kellen, and someone on their behalf, Maxwell, directed Robson to bring one or more underage girls to the residence. Robson generally sought out economically disadvantaged underage girls from Loxahatchee and surrounding areas. Upon arrival at Epstein's mansion, Robson would introduce each victim to Kellen, who gathered the girl's personal information. Defendant Kellen would then bring the girl up a flight of stairs to a bedroom that contained a massage table. Kellen would then leave the girl alone in the room, whereupon Epstein would enter wearing only a towel. Epstein would then remove his towel, lay down naked on the massage table, and direct the girl to remove her clothes. Jesus Christ. Epstein would then perform one or more lewd, lascivious, and sexual acts, including touching, etc., and coerce or attempt to coerce the girl to engage in lewd acts or prostitution. Jesus. Consistent with the foregoing plan, Robson recruited plaintiff to give Epstein a massage for monetary compensation. Robson brought plaintiff to Epstein's mansion in Palm Beach. Plaintiff was introduced to Kellen, who led her up the stairs. Sarah Kellen with a massage table, laid out massage oils. Plaintiff was alone in the room. Remove the clothes. Epstein returning wearing only a towel, etc. Lay down the floor. Remove. Start to rub Epstein's back. Sit back. Out of fear, she complied. After a period of time, Epstein got up from the table behind the door. For several minutes, plaintiff heard loud noises and moans. Thereafter, Epstein returned to the massage table and laid face up on the table. Epstein told plaintiff to continue to massage and told her to sit on top of him. Jesus Christ. Jesus Christ. Jesus. Jesus. Can't read any of that. Write down her name, phone number, and left the room. Plaintiff was then able to get dressed, leave the room, and go back downstairs into the kitchen. Epstein, Kellen, Robson were waiting for them. Epstein paid the plaintiff $300. Epstein paid Robson $200 for bringing them. He's running the world's most disgusting affiliate program. Jesus Christ. As a result of the encounter, the 14-year-old plaintiff experienced confusion, shame, humiliation, embarrassment, and the assault sent her life into a downward spiral. Defendants filed a notice of removal with this court on July 18th. Defendants assert this court has jurisdiction pursuant to 28 U.S.C. The amount in controversy exceeds $75,000. Defendant Epstein is a citizen of the Virgin Islands. Defendant Sarah Kellen is a citizen of New York, as plaintiff is a citizen of Florida. Complete diversity exists in this court's jurisdiction is alleged to be proper. As for Haley Robson, defendants claim Robson was fraudulently joined to defeat diversity jurisdiction. Plaintiffs have moved to remand the action, claiming that Robson was not fraudulently joined to the action. As such, plaintiff asserts the complete diversity does not exist, and this court does not have jurisdiction over this case. Standard of review. This jurisdiction shit is fucking annoying. Conclusion. Accordingly, it is hereby ordered and adjudged as follows. Plaintiff's motion to remand is granted. This case shall be remanded to the Circuit Court of the 15th Judicial Court in Palm Beach County, Florida, for lack of subject matter jurisdiction. The clerk of this court is hereby directed to forward a certified copy to the clerk of the Circuit Court of the 15th. Okay. All pending motions are hereby denied without justice as moot. This case is closed, done, and ordered in chambers at West Palm Beach County. Who is the judge on this? Kenneth A. Mara. What are all pending motions? See, the fact that all this is done in like paper is kind of doo-doo poo-poo. All pending motions should have a hyperlink. This is an old and archaic profession. Let's see. Remanded to the 15th Circuit. The Epstein trafficking and prostitution case. This is 10/3/2008. Oof ba boof. All right. This is 8/11/09. What's this one? Order and opinion. United States District Court, Southern District of California. So this is after the remand. Jane Doe 2 versus Epstein. Sarah Kellen. Who's Sarah Kellen? Was she one of these like indoctrinated people? Order and opinion. This clause is before the court upon defendant Jeffrey Epstein's motion to dismiss plaintiff's complaint filed May 6, 2009. The motion is now fully briefed and ripe for review. The court has carefully reviewed the motion, amended response, and reply and is otherwise fully advised in the premises. How is Epstein's motion? How do you make a motion to dismiss on this when it's remanded to the upper court? You have a motion to dismiss on jurisdiction, you sneak fuck. This cause is before the court upon defendant Jeffrey Epstein's motion to dismiss plaintiff's complaint. How do you even find jurisdiction when everyone lives in different places? Motion is now fully briefed and ripe for review. The court has carefully reviewed. Okay, background. Give me the actual. Apparently they're okay. Let's see what the ruling. Based on the following, is hereby ordered and adjudged as follows. Defendant Jeffrey Epstein's motion to dismiss is granted in part and denied in part as follows. Plaintiff's claim is dismissed without prejudice to amend to allege that defendants used the mail or any facility or means of interstate or foreign commerce to violate that. So they tried to get RICO, I guess. Except as the question of whether plaintiff is limited to one award of statutory damages on which the court reserves ruling. The remainder of defendant's motion is denied. Done and ordered in the chambers. Okay, I need to read this. What the fuck? Defendant argues in his motion that this case should be dismissed by plaintiff because plaintiff previously filed a case in state court based on the same set of facts as in this case. But it was remanded to the upper court. Plaintiff filed the instant case alleging violations of that, and filed the state case alleging sexual battery and civil conspiracy. Defendant argues that the state court would have concurrent jurisdiction over plaintiff's claim, and that the exceptional circumstances exist requiring dismissal of the federal action in favor of the first filed state action. So that's a defense, is that, if you're trying to get somebody for doing something awful and you go to the state first and then federal, because the state thing happened first, the federal one needs to be dropped? Is that actually true? Is that why he got the plea deal? The exceptional circumstances test is set forth in Moses and Colorado River. I'm not going to read that. Here, the first factor is inapplicable because neither the federal court nor the state court has assumed jurisdiction over any property. The second factor, the inconvenience of the federal forum, focuses primarily on the physical proximity of the federal forum to the evidence and the witnesses. This factor does not weigh in favor of dismissal of the state court proceeding. The focus of the third factor is avoiding piecemeal litigation. Plaintiff has brought claims under federal law in the federal court action and under state law in the state court action. The fact that the state court may have concurrent jurisdiction over that, and the fact that plaintiff could have chosen to bring her claim as part of her state court action, do not preclude her from filing a claim in federal court. Although many of the same facts are involved in both cases, plaintiff has brought different causes of action in each forum and has not brought any federal claims in her state court case. By litigating cases involving many of the same facts simultaneously in both federal and state court, plaintiff risks the potential application of res judicata. What the fuck is res judicata? Res judicata is a principle most used in civil litigation. Directly translated to res judicata means a matter judged. Specifically, the res judicata principle indicates that there is a final judgment based on merits, that another plaintiff cannot relitigate the same matter for the same cause of action. Oof baboof. The claims of the forum, which is the last to decide the case. See Jang versus United Technologies Corp. Action to bring state claims in one suit and then file a second suit of federal causes of action. That claim was barred in federal court after the plaintiff elected to bring only its state law claims in the initial state court litigation, where both state and federal claims relied upon the same essential facts. Montana, United States. The presence of that risk, which plaintiff has apparently chosen to take, does not preclude plaintiff from proceeding in both fora and on separate claims. Different actions, same facts. Apparently that means one matter being closed does not close all of them, despite them being the same facts. Okay. The fourth factor, the order in which the jurisdiction was obtained, should not be measured exclusively by which complaint was filed first, but rather in terms of how much progress has been made in the two actions. Interesting. Here, the state action was filed first, and defendant Epstein has responded to the complaint in both cases. Even assuming that the state court litigation has progressed further than the federal litigation, this factor does not weigh heavily in favor of dismissal, considering the overall analysis of the other five factors. The fifth factor, whether federal or state law will be applied, does not point toward dismissal, as the federal case raises only federal causes of action. Finally, the sixth factor, the adequacy of the state court to protect the parties' rights in equipoise. Equipoise. In the same standing? Equipoise? Equipoise.
Equipoise.
Equipoise. Balance of forces or interest. Balance or counterbalance. Finally, the sixth factor, the adequacy of the state court to protect the parties' rights, is in equipoise, meaning they're balanced. There's no reason to defer to the state court pursuant to this factor. Okay. Federal court cannot properly decline to exercise its statutory jurisdiction, however, simply because judicial economy might be served by deferring to a state court. Hold on. A federal court cannot properly decline to exercise its statutory jurisdiction. However, simply because judicial economy might be served by deferring to a state court. Federal courts have a virtually unflagging obligation to exercise the jurisdiction given to them. This is especially true here because this case asserts a federal cause of action and the state case does not. Defendant has failed to demonstrate that exceptional circumstances require dismissal of this case in deference to the pending state court proceeding. Okay, that's fine. Complaint sufficiently alleges that defendant Epstein knowingly persuaded, induced, or enticed plaintiff to engage in acts of prostitution when plaintiff was under the age of 18. This, however, the complaint does not allege the defendant used the mail or any facility or means of interstate foreign commerce. Okay. Plaintiff asserts in her response that the telephone system is clearly a facility of interstate commerce and states that she is prepared to allege that defendants Epstein and Kellen used an instrumentality of interstate commerce, namely Kellen's cellular telephone, to solicit plaintiff. Plaintiff shall be permitted to amend her complaint accordingly. Lastly, okay, because they didn't include that, I guess. Lastly, Epstein asserts the plaintiff has failed to state cause of action for conspiracy to violate that for the same reason she failed to cause that against Epstein. As explained, supra. What is supra? Supra is a Latin term meaning above. It is often used in legal writing to refer to the reader to an earlier portion of the document, case, or book. As explained before. Plaintiff shall be permitted to amend her complaint to allege that defendant used the mail or any facility or in interstate foreign commerce to violate that. Based on the foregoing is ordered and adjudged as follows. Defendant Jeffrey Epstein motions to dismiss is granted and denied in part. As follows. Plaintiff's claim to dismiss without prejudice to amend the defendant's use of except as to the question of whether plaintiff is limited to one award of statutory damages on which the court reserves ruling. The remainder of defendant's motion is denied. The defendant's motion is denied. It is allowed when it comes to interstate commerce. Okay, now I understand. Jesus. Dude, legal shit sucks. CMA, plaintiff versus Jeffrey Epstein and Sarah Kellen. 12-10-09. This cause is before the court. Okay. What is the order here? Ordering the judge as follows. Defendant Jeffrey Epstein's motions to dismiss First Amendment complaint for failure to state cause action and motion for what is granted in part and denied in part. Follow. Plaintiff is authorized to amend counts 1XX of her complaint, specifically plead any predicate act upon which she relies in advancing her claim under this. Additionally, plaintiff shall replead count sexual battery to incorporate only the prior paragraphs which specifically relate to plaintiff's common law sexual battery claim and not to include those prior paragraphs which relate to other statutory claims. The remainder of defendant's motion is denied. Motion is denied. Defendant's motion is denied. Order granting the motions of the trustee and Jeffrey Epstein to issue a writ of habeas corpus ad testificandum. What is a writ of habeas corpus ad testificandum? A writ of habeas corpus. A writ of habeas corpus orders the custodian of an individual in custody to produce the individual before the court to make an inquiry concerning his or her detention, to appear for prosecution, or to appear to testify. State courts, okay, confusing. Habeas corpus orders the custodian of an individual in custody, so his lawyer or the jail people, to produce the individual before the court, so to make an inquiry concerning his or her detention, to appear for prosecution, or to testify. Habeas corpus lets the person that owns a person show up to a place where they can be adjudicated. State courts may issue writs to prisoners or custodians to produce federal prisoners. Okay. Ad testificandum for to testify, I would presume. Okay. Background. The trustee proposes a 10-day deposition of Scott Rothstein, broken up into smaller depositions pertaining to 29-122 bankruptcy adversary actions. Upon agreement with the government, second deposition would take place on June 4th. Taken by video conference, it will not be videotaped. No party opposes the deposition taking place, as the court stated in today's hearing before addressing the objections to the manner in which the trustee and government proposed to take deposition. Videotaping. Time limit the court first concludes they will grant the trustee's motion and will set a deposition of Scott Rothstein for 10 business days. Who is Scott Rothstein? Scott Rothstein is an American disbarred lawyer, convicted felon, and former managing shareholder, chairman, and chief executive of the now defunct Rothstein Rosenfeld Adler law firm. He funded an extravagant lifestyle with a $1.2 billion Ponzi scheme, one of the largest such in history. Holy shit. On December 1st, 2009, Rothstein turned himself into authorities and was subsequently arrested. Charges related to the Racketeering Influence Corrupt Organizations Act, RICO. Although his arraignment plea was not guilty, Rothstein reversed his plea to guilty 5 federal crimes. Rothstein was denied bond. Ruled due to his ability to forge documents, he was considered a flight risk. He was sentenced to 50 years. 50 years. All right. How does this work with Epstein? This is the only thing we can find. This was used. Where was this used? A. Roger Stone. It's weird that all these people are tied together. Why do I keep hearing the name Roger Stone? Epstein. What happened here? The Jeffrey Epstein and Bill Clinton ploy. A key question regarding Scott Rothstein's fraudulent scheme that until now has gone largely unanswered. How did he lure so many rich and powerful locals to pour tens of millions into the estimated billion-dollar Ponzi that imploded last weekend? One way he did was by tricking investors into believing that... Where is... He told investors that... Okay, one way he did it was by tricking investors into believing that his firm was representing numerous underage girls who had sex with Palm Beach billionaire and convicted sex offender Jeffrey Epstein. Wait. Scott Rothstein. Who is this? United States Southern District debtor. He's already in jail. Take the deposition of Scott Rothstein. Jeff Epstein's motion for a writ of habeas corpus to be included in the next session of Rothstein's deposition. Responses to the trustee's motion. Why did he say that? The central figure in a criminal action brought by the United States of America regarding fraudulent activities undertaken by Rothstein while he controlled the now bankrupt firm was examined in the RRA bankruptcy proceeding deposed by several individuals. These parties previously had filed motions to depose, resulting in bankruptcy order. Just prior to deposition in conjunction with the statutory deadlines, the trustee filed additional adversary. Where is... come on. The trustee proposes a 10-day... But... How is he connected to Epstein? Order granting the motions of the trustee and Jeffrey Epstein to issue a writ. Why can Jeffrey Epstein sue this guy? Jeff Epstein asks for fucking habeas corpus ad testificandum to depose Scott Rothstein. The trustee opposes the participation of Jeff Epstein on the grounds that his action has nothing to do with the bankruptcy actions and will open the floodgates to requests by private parties to depose Rothstein. Mr. Epstein filed his own motion for writ of habeas corpus in a testimony to question Rothstein regarding his separate state court action in Palm Beach against Rothstein and former RRA partner Epstein was defended in the cases that Rothstein used to create structured settlements that were used to perpetuate his Ponzi scheme. That's so fucking weird. Epstein reports that he attempted to secure a deposition through a state court action. Epstein recognized that absent this ongoing bankruptcy proceeding, his chances of obtaining access to depose Rothstein are small. Upon review of the record, Epstein's motion is supported by specific evidence that Rothstein had personal involvement in the civil actions filed against Epstein, which supported the Ponzi scheme. Wait. Involved in what way? He was involved in the civil actions in what way? Has also undertaken all steps he could to take secure Rothstein's deposition. The court concludes that Epstein has met his burden to be included in the second deposition of Scott Rothstein. Epstein's participation. What the fuck? Jeffrey Epstein's motion, writ of habeas corpus and testified to depose Scott Rothstein to be included is hereby granted. What the fuck? Scott Rothstein runs a Ponzi scheme and convinces people that he's representing the young women that Epstein attacked. Epstein is granted habeas corpus to get Rothstein to be deposed. That is so fucking weird. When is this? When is this? 2012. What is happening here? Okay. Jane Doe number 8 versus Epstein. 11/18/2009. Opinion order a motion to dismiss. This cause is before the court upon defendant Jeffrey Epstein's motion to dismiss. Of course, plaintiff Jane Doe number 8 filed a response to the motion and defendant filed a reply. The court has carefully reviewed the motion. Filed her complaint against Epstein, suit alleging sexual accounts of battery, intentional infliction of emotional distress, coercion. All right. What's the discussion here? Defendant's motion to dismiss is granted in part and denied in part. Defendant's motion to dismiss count 1 is denied. Defendant's motion to dismiss count 3 is granted. What was count 3? Is hereby dismissed without prejudice with leave. What is count 3? Coercion and enticement to sexual activity in violation of USC. Why? Not enough evidence. Then responding to defendant's motion assumes that the action accrued on the date when defendant's alleged sexual misconduct occurred, but determination of when the limitations period, statute of limitations. Ordinarily, plaintiff need not negotiate the affirmative defense of the statute of limitations. La grasta. When on the face of the complaint, it appears that the limitations period has run. Oof ba boof. He only got off on statute of limitations on number 8. I feel like they changed this recently, where for if it's a crime against a minor, especially if it's like a sexual crime against a minor, they expanded the statute of limitations to avoid stuff like this, because this is kind of fucked that he got off just because the crime was too old. At least on that count. At least count 1 is denied. Oof ba boof. Jane Doe number 4. What does she bring? Count 1, sexual and battery. Count 2, infliction of emotional distress. Count 3, coercion. I have a feeling this is going to be similar. Jane Doe 4. Two 1209. Let's see. The reason stated herein, defendant's motion to dismiss and motion for more definite statement directed by the plaintiff's defendant is granted in part and denied in part. I'm starting to see this is very common. Defendant's motion to dismiss, and these are all at the circuit court. Defendant's motion to dismiss or for a more definite statement, 1 is denied. Defendant's motion to dismiss or for a more definite statement as to count 3 is granted in part and denied in part. Defendant's motion to dismiss is denied. However, plaintiff must file another complaint which includes more definite statements as to count 3. Coercion. Defendant's motion to strike the citation in the is what? Is granted. Done and ordered. Kenneth A. Mara. This judge, it's the judge on all the cases. I wonder if there's some spooky shit going on with this judge. Kenneth A. Mara, senior United States District Judge, United States. What does he look like? I bet he looks like a fucking creepy motherfucker. He smiles a lot. I would have guessed he would be like a spookier guy. Just looks like a grandpa. All right, Jane Doe number 2. Okay. Motion to dismiss denied. Motion to dismiss denied or granted. It's all the same. All these are the same. February 2009. 7 2008. Number 6 2009. 2009. 2009. 2009. 2009. 2009. 2019. Ooh. All right, this is interesting. United States Court of Appeals. 7/3/2019. Julia Brown, Miami Herald Company, interveners appellants versus Ghislaine Maxwell versus Virginia L. Giuffre. The interveners and appellants, the defendants, and the plaintiff. So it's Virginia versus Ghislaine. Okay. On appeal from the United States District Court for the Southern District of New York, before Kavanagh's Pooler Journey Circuit Judges, Alan Dershowitz, Michael Cernovich, and the Miami Herald Company appeal from certain orders of the United States District Court for the Southern District of New York, denying their respective motions to unseal filings in a defamation lawsuit. Why would you deny the unsealing of the files, you jerks? We conclude that the district court failed to conduct the requisite particularized review when ordering the sealing of the materials at issue. Oh, they're... Okay, hold on. Cernovich, the Herald, and Dershowitz. They appeal. They're appealing the denial of their motions to unseal. We conclude that the district court failed to conduct the requisite particularized review when ordering the sealing of the materials at issue. At the same time, we recognize the potential damage to privacy and reputation that may accompany public disclosure of hard-fought, sensitive litigation. We therefore clarify the legal tools that district courts should use in safeguarding the integrity of their dockets. Accordingly, we vacate the district court's orders entered on November 2nd, 2016, 2018 order the unsealing of the summary judgment record as described further herein, and remand the cause to the district court of the particularized review remaining sealed materials. Judge Pooler concurs in this opinion, except insofar as it orders the immediate unsealing of the summary judgment record without a remand. Interveners: Alan Dershowitz, Michael Cernovich, and the Miami Herald appeal from certain orders of the United States District Court for the Southern District of New York, denying their respective motions to unseal filings in the defamation suit. We conclude the district court failed to conduct the requisite particularized. Okay, we read that already. Recognize vacate the order of remand. Okay, background. Origins of this case lie in a decade-old criminal proceeding against financier Jeffrey Epstein on June 30, 2008. Epstein pleaded guilty to the Florida state charges of soliciting, procuring, prostitution, etc. Masseuses, some of whom were under 18, Florida's age of consent. Pursuing to an agreement with state and federal prosecutors, Epstein pleaded to the state charges. He received limited jail time, registered as a sex offender, and agreed to pay compensation to his victims. In return, prosecutors declined to bring federal charges. Super weird. I still don't understand why exactly, except for maybe, possibly, the order of operations was wrong. Shortly after Epstein entered his plea, two of his victims, preceding Jane 1 and Jane 2, filed suit against the government of the Southern District of Florida and the Crime Victims' Rights Act. The victims sought to nullify the plea agreement, alleging the government failed to fulfill its legal obligations to inform and consult with them in the process leading up to Epstein's plea deal. Number 1. On December 30, 2014, two additional unnamed victims, one of whom is now self-identified appellee Virginia Giuffre, petitioned to join the CVRA case. These petitioners included in their filings not only descriptions of sexual abuse by Epstein, but also new allegations of sexual abuse by several other prominent individuals, including numerous prominent American politicians, powerful business executives, foreign presidents, as well as a known prime minister and other world leaders, as well as Dershowitz and Ghislaine Maxwell. What the fuck? Dershowitz moved to intervene, seeking to strike the outrageous and pertinent allegations made against him, to request a show cause order to the attorneys that have made them. Exercising its authority to strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter on its own. The Florida District Court struck all allegations against additional parties from the pleadings, including those against Dershowitz, and therefore denied Dershowitz's motion as moot. So they made allegations, and I guess they didn't make them properly. And he was like, "Ha! Get fucked." The stricken allegations, however, quickly found their way into the press, and several media outlets published articles repeating Giuffre's accusations. In response to the allegations on January 3, 2015, Maxwell's publicist issued a press statement declaring that Giuffre's allegations against Ghislaine Maxwell are untrue, and her claims are obvious lies. On September 21st, 2015, Giuffre filed the underlying action against Maxwell in the Southern District of New York. Giuffre alleged that Maxwell had defamed her through this and other public statements. Extensive and hard-fought discovery followed. I want that fucking discovery. Due to the volume of sealing requests filed during discovery, on August 9, 2016, the district court entered a sealing order that effectively ceded control of the sealing process to the parties themselves. Bro, what the fuck? What the fuck? The sealing order disposed of the requirement that the parties file individual letter briefs to request sealing, and prospectively granted all of the parties' future sealing requests. In total, 167 documents, nearly 1/5 of the docket, were filed under seal. What the fuck? Each party was granted right to seal whatever they wanted. What the fuck? These documents include inter alia motions to compel discovery, motions for sanctions and adverse inferences, motions in limine, and similar material. On January 6, 2017, Maxwell filed a motion for summary judgment. The parties submitted their memoranda of law and supporting exhibits contesting this motion under seal. On March 22, 2017, the district court denied the motion in a heavily redacted 76-page opinion. I want this. Once again, the entire summary judgment record, including the unredacted version of the district court opinion denying summary judgment, remained under seal. On May 24, 2017, Maxwell and Jeffrey executed a settlement agreement and the case was closed. Oof ba boof. That sucks. I wonder how many millions of dollars it was. Motions to intervene and unseal. Over the course of the litigation before Judge Sweet, 3 outside parties attempted to unseal some or all of the sealed material. On August 11, 2016, Dershowitz moved to intervene, seeking to unseal 3 documents that, he argues, demonstrate that Jeffrey invented the accusations against him. That's interesting. On January 19, 2017, Cernovich, an independent blogger and self-described popular political journalist, moved to intervene, seeking to unseal the summary judgment record. And Dershowitz joined this motion. I wonder if actually there's some stuff in there that would be damning for the... What's the name? Not the defendant. What's the thing? I'm on page 8. The plaintiff. On April 6, 2018, after the case had been settled, the Herald moved to intervene and unseal the entire docket. The district court granted each of these motions to intervene, but denied the related request to unseal in orders entered in. Damn. The appellants timely appealed from each of the orders denying their respective motions to unseal. Although each appellant seeks the release of a different set of documents, all argue that the district court failed to analyze the documents individually or properly apply the presumption of public access to court documents. We therefore ordered that the appeals be heard in tandem and held argument on March 6, 2019. On March 11, 2019, we issued an order to show cause why we should not unseal the summary judgment motion, included any materials filed in connection with this motion, and the district court's summary judgment decision. The parties timely filed their responses. Discussion. I just want to know what happened. While the law governing public access to material is largely settled, we have not yet adequately addressed the potential harms that often accompany such access. These harms are apparent over 40 years ago. The Supreme Court observed that without vigilance, courts' files might become a vehicle for improper purposes. Our legal process is already susceptible to abuse. Unscrupulous litigants can weaponize the discovery process to humiliate and embarrass their adversaries. Shielded by the litigation privilege, bad actors can defame opponents in court. Bad actors can defame opponents in court pleadings or depositions without fear of lawsuit and liability. Unfortunately, the presumption of public access to court documents has the potential to exacerbate these harms to privacy and reputation by ensuring that damaging material irrevocably enters a public record. But who are they defending? Imagine it's actually like the... how did I forget this word already? The plaintiff? Imagine it's actually the plaintiff that they're defending by doing this. We therefore take the opportunity to describe the tools available to district courts. Okay, I don't need that. Summary judgment materials. With respect to the first category of materials, well settled. Documents submitted to a court for its consideration in a summary judgment motion are, as a matter of law, judicial documents to which a strong presumption of access attaches under both common law and First Amendment. In light of this strong First Amendment presumption, continued sealing of the documents may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. In this case, the district court erred in several respects. First, it failed to give proper weight to the presumption of access that attaches to documents filed in connection with summary judgment motions. District court reasoned that the summary judgment materials were entitled to a lesser presumption of access because summary judgment was denied by the court. In assigning a lesser presumption to such materials, the district court relied on a single sentence of dicta from our decision United States v. Amodeo. We have since clarified, however, that this sentence was based on a quotation from a partial concurrence and partial dissent in the D.C. Circuit. Cringe! and is thus not considered considered decision of either this court or the D.C. Circuit. In fact, we have expressly rejected that proposition that different types of documents might receive different weights of presumption based on the extent to which they relied upon they were relied upon in resolving a motion. All right, where's the shit? Remaining sealed materials. Give me the shit. Give me the shit. Where's the shit? Where's the shit? Where's the shit? Okay. Okay, come on. Come on. Cautionary note. Come on, come on. Conclusion. Materials submitted in connection with motion for summary judgment are subject to a strong presumption of public access. The summary judgment record at issue will be unsealed upon issuance of our mandate, subject to minimal redactions. Material submitted in connection with and relevant to discovery motions, motions in limine, and other non-dispositive motions are subject to a lesser but still substantial presumptive access. District Court is directly to review the remaining sealed materials individually and unseal those materials as appropriate. District Court shall exercise the full range of their substantial powers to ensure their files do not become vehicles for defamation. For the foregoing reasons, we vacate the orders of the District Court entered 2017. Order the unsealing of the summary judgment record as described herein, and remand the cause to the District Court for the particularized review of the remaining materials. In undertaking this task, the District Court may be well served in... Okay. I want to read this summary judgment. Okay, how do I find this? Maxwell motion for summary judgment unsealed. How do I find this? How do I find this? For the foregoing reasons, we vacate the orders, the unsealing of the summary judgment. It was Maxwell, Virginia v. Maxwell. Well, who ordered the summary judgment? Upon issuance or amended, a minimally redacted version of the summary judgment record will be made accessible on the Court of Appeals docket. Court of Appeals docket. We have implemented minimal redactions to protect the information. Jeffrey Maxwell 2019 summary judgment record. Virginia Maxwell, plaintiff's response to defendant's motion for summary judgment. Undisputed facts. This is the response. I want the actual summary. I want... Maxwell's motion for summary judgment. All right, let's just read this. Preliminary statement. Hold on. Then undisputed facts. It's an undisputed fact the multiple witnesses deposed in this case have testified the defendant operated as convicted pedophile Jeffrey Epstein's procurer of underage girls. Undisputed fact that Joanna Schuberg testified defendant lured her from her school. Undisputed that Tony Figueroa testified the defendant would call him to bring over underage girls. Undisputed fact that Ronaldo Rizzo testified the defendant took the passport of a 15-year-old Swedish girl and then threatened her when she refused. Lynn Miller testified she believed defendant became Miss Geoffrey's new mama. Undisputed fact that Detective Joseph Roseri testified that he sought to investigate defendant in relation to investigation of. Undisputed fact that pilot David Rogers testified that he flew defendant and Miss Geoffrey at least 23 times. Undisputed fact that Sarah Kellen, Nadia Marchenkova, and Epstein invoked the Fifth Amendment when asked about defendant trafficking girls for Epstein. Undisputed fact that Juan Alessi testified to the defendant was one of the people who procured some over 100 girls, had to clean the defendant's toys. Undisputed fact, defendant is unable to garner a single witness through discovery who can testify that she did not act as the procurer of underage girls and young women for Jeffrey Epstein. Documentary evidence also shows defendant trafficked Ms. Geoffrey and procured her for sex while she was underage. The flight logs. The flight logs. All right. Let's go straight to page. Sex slave Amazon book receipt? What the fuck? What the fuck is going? Okay. Page 12. Together, C. McCauley, December at Exhibit 1, Alessi Depp. After that day, undisputed facts. Let's see, flight. Flight logs even revealed 23 flights the defendant shared. Defendants tried to spin these inconsequential mistakes of memory into talismanic significance and evidence of form of bad faith litigation, but this claim fails under the weight of evidence. As the court knows, the clear weight of the evidence establishes defendant's heavy and extensive involvement in Jeffrey Epstein's trafficking ring. Living with her, Jeffrey Epstein, Jeffrey was a minor, traveling, including 23 documented flights. All aboard the Lolita Express. Flight logs reveal the many trips Bill Clinton and Alan Dershowitz took on pedophile Jeffrey Epstein in the Daily Mail. It is undisputed fact that pilot David Rogers testified that he flew the defendant. Flight logs. Okay. Notably, defendant's deposition. Defendant refused to admit that she flew with Mrs. Geoffrey and denied that she appeared in Epstein's flight logs. However, David Rogers, Epstein's pilot, testified the passenger, the initials GM, was in fact Elaine Maxwell, that he was a pilot on at least 23 flights. Okay. C. McCauley declared Exhibit 41, Rogers' deposition, etc. Flight recording evidence, defendant flying with Miss Geoffrey. From the deposition. I want photos. I want the actual logs, dude. Exhibit 15, David Rogers, June, deposition. Exhibit 41. Exhibit 1 at flight numbers 1433. Flight logs. Documentary evidence also showed the defendant trafficked Miss Geoffrey and procured her for defendant has never offered a legal explanation for what she was doing with and why she was traveling with a minor child on 21 flights while she was a child, including 6 international flights. Aboard a convicted. Okay. Motion for summary judgment, as well as all previous briefing papers, are absolutely silent on those damning documents. The photographs. Oh, shit. Would you look at that? Throw them out in a briefing and a deposition. Testimony. Defendant never offered an explanation regarding Ms. Geoffrey's photographs of her. Defendant and Epstein. She never offered a legal explanation for why Prince Andrew was photographed with his hand around Ms. Geoffrey's bare waist while she was a minor child while posing with defendant inside defendant's house in London. This particular photograph corroborates Miss Guffrey's claims, and there's no reasonable explanation why an American child should be in the company of adults not her kin in the London house owned by the girlfriend of a now convicted sex offender. Holy shit. Ms. Guffrey also produced pictures of herself taken when she was in New York with defendant Epstein on a trip to Europe with defendant Epstein. Yeah, that is a child. Finally, among other new photos, which included full news of defendants, Miss Guffrey produced images of females at the Palm Beach police confiscated during the execution of the warrant, including one photograph revealing the bare bottom of a girl who appears to be prepubescent. Jesus Christ. Victim identification letter. In 2008, United States Attorney Office for Southern District of Florida identified Miss Guffrey as a protected victim of Jeffrey's sex abuse case. The U.S. Attorney mailed Miss Guffrey a notice of her rights as a crime victim under the CVRA. Psychological records. "21 flights. 23 flights. There exist flight logs evidencing Miss Guffrey flying to London alongside defendant and Epstein private plane, and a photo of Miss Guffrey, defendant, and the prince, the defendant, ever offering a legal reasonable explanation for that photo being taken, or for traveling with a year-old girl overseas. Undisputed fact that pilot David Rogers testified that okay. How do I find these flight logs? Have the Epstein flight logs exhibits been unsealed? Epstein flight logs. This is going to be tough. Del Coleman, Levy, damn. All right, I need to like download this or something. This is going to be hard to original document PDF. Okay. Mr. I don't know. Del Coleman, Saul Levy. Below the call. Man, it is very hard to read this. Oh, yes, we got here. Test flight. Mark Epstein, Linda, Jeff Epstein, Ghislaine Maxwell, Jeffrey, Dana? Jeffrey plus one female. Jeffrey, Dana, Roger Stone, plus one Pax, Jeffrey, Epstein, Jeffrey, Ava Anderson, Ghislaine, Roger Stone. I don't know if that says Stone. Roger something. I wonder if ChatGPT could read this better than me. Above. Wait, so now I'm a little confused. Because this stuff has been unsealed. If the stuff has been unsealed, why do people keep asking Trump about, oh, when are they going to unseal the documents? I feel like they've already unsealed it, no? Steve Zuckerman, Judy Tuckerman. Is this trying to, can I? No. Yeah, it's not going to be able to do that. Yitzhak Perlman. Who? Yitzhak Perlman? There's got to be a lot of different Yitzhak Perlmans. Why is Yitzhak Perlman fucking flying to the shit? His whole family, all the Perlmans. Maybe it's a different Perlman. I don't know. James Murphy. Pags. Has someone translated all of this? Has someone translated the handwriting in the Epstein flight logs? Documented flight 1991. Each page of the logs is signed. Lower left hand, David Rogers, served as testified for Garner, the pilot. Long before ascending to the perch of 43%, admitted ties to Epstein and Maxwell have been well documented. 2002, New York Magazine. Known Jeff for 15 years, called him a terrific guy. Trump first appears in the Epstein flight logs in April 1993. Months later, he took 2 trips to Epstein's plane. Yeah, bro. And my brother told me, which page was this? Which page was this? Months later, he took 2 trips on Epstein's private plane. Around the time Trump's daughter, Tiffany Trump, was born, Trump, along with Epstein, Maxwell, others, flew to Palm Beach, Florida, to Teterboro, New Jersey. October 17th, 1993. October 1992. 93. That's January. August. October 93. Donald Trump. Let me do a quick I told you so. Now I have to zoom in here and put a red line under Donald Trump. And I have to send it to the whole group chat. I sent Trump and Epstein were friends in the camel case shit. All right. Okay. Summary judgment. They unsealed it. That's good. Okay, cool. Circuit Judge, dissenting in part, I join the court's opinion in every respect, but 1, the decision to unseal the summary judgment record ourselves. I agree that all or most of the material must be unsealed. Nevertheless, in my review, the district court is better suited to the task. As a court's opinion recognizes in connection with the remaining sealed materials, the district court is better positioned to communicate with the parties and any non-parties whose privacy interests might be affected by unsealing. On that score, it's worth clarifying here that the breadth court's unsealing order, it unseals nearly 2,000 pages of material. The task of identifying and making specific redactions in such a substantial volume is perilous. The consequences of even a seemingly minor error may be grave and irrevocable. Moreover, although I share the majority's concern about avoiding delay, I would alleviate that concern through other means. Okay, fine. Okay. Is this the official... I lost the unsealed document. All right, hold on. Let me find something here. Ay, ay, ay. Motion to dismiss for more definite statement. No. I need to find where I was just at. Jeffrey Epstein, flight logs, summary judgment record. No. So this is the response to the motion for summary judgment. I need the actual motion for summary judgment. Jeffrey Maxwell, motion for summary judgment. Southern District, New York. All right. 2. The defendant, Glenn Maxwell, has moved pursuant to rule for summary judgment, dismissing the complaint. Counsel for Maxwell, opinion. How do I get this? How do I get this? Is it here? Case details. Motion for summary judgment. How do I find this? Supporting 3D 428. Where's the actual... Can I down... Is it in the PDF? God damn it! Maybe it'll have... Supporting document. Guthrie versus Maxwell. Motion for summary judgment. Come on. Thereby precluding summary judgments. Okay. I need the reference for the motion. How do I find the actual motion? Filing 285, unsealed summary judgment record. Filing 285. Filing 285. This docket was last retrieved September 13, 2019. A more recent docket may be available from Pacer. Guthrie versus Maxwell, unsealed summary judgment record. How do I find it? How do I find it? Is this the whole thing? Bro. Okay. All right, I pressed the button to get it. It's not working. Let me look at the code. Cannot set properties of null. Cannot create them with duplicate ID. They have a fucking JavaScript error. Oh, I'm trying to get a document. They got a fucking document error. Maybe if I turn off my ad block. Ad block is not even on. Dude. Okay. Excerpts of song were submitted under seal as part of the now unsealed summary judgment record, are not subject to the Maxwell Protective Order. However, where such materials have already been unsealed, either court or the Court of Appeals, they may freely disclosed so ordered. Can I find... Is this the whole thing? Is this the whole thing? Download PDF. Now unsealed summary judgment record. See infra number 1. All documents produced or deposition or writing testimony given by any of the following individuals whom Geoffrey has testified she was sexually trafficked to by Epstein: Prince Andrew, Jean-Luc Brunel, Glenn Dubin, Stephen Kaufman, Marvin Minsky, George Mitchell, Thomas Pritzker, Bill Richardson, Leslie Wexner, and then redacted. Prince fucking Andrew. Appendix A, all documents concerning Alan Dershowitz. Where's appendix? Where's the appendix? Where the fuck is it? Why is it so hard to find? Why is it so hard to find? Okay. Filing 1302. Wait. Can I go? That's 1097. Can I go 1302? Page not found. What the fuck? I go here. 1097. You can't click on it. How am I supposed to find it? How do you find it? How? I'm so confused. Alan Dershowitz, Michael Cernovich, Julie Brown, Miami Herald Media Company, United States Virgin Islands. Okay. What if I just do mandate of USCA, notice of appeal, if I have TGP Communications, affirmed. Where's the... Whoops. Where is the goddamn summary judgment. Okay. Recording by unsealed summary judgment record. The court further orders the unsealing of the summary judgment record. Where's the actual summary judgment record? Unsealing. Unsealing. Motion for summary judgment is denied. For the reasons above, the motion for summary judgment is denied. Summary judgment is denied. Notice of filing response to proposed intervener Michael Cernovich, opposition to notice of plaintiff's redactions to the court's order denying summary judgment. Minute entry. Notice of plaintiff's proposed redactions. Reply to response to motion. Motion in limine to exclude evidence barred as a result of plaintiff's summary judgment concessions. Where's her actual summary fucking judgment order? Minute entry. Endorsed letter addressed to Judge W. Robert, the extension of the page limit for Ms. Maxwell's reply in support of summary judgment. Declaration of Laura. Applied to response motion 540. Motion for summary judgment. If is 540 motion for summary judgment? Motion for summary judgment. Okay. I think we're making progress. I think now if I search January 9, 2017, Maxwell, filing 540, motion for summary judgment. Nope. How do I find this? How do I find this? How do I find this? $540. Denying motion for summary judgment filed by Ghislaine Maxwell, signed Robert. Main document. Is this it? Memorandum and opinion. This is it. This is it. How long is this? Holy fucking fuck. Holy shit. Look at that. Oh my god. Where's the unsealed one? Where is the unsealed, unredacted motion for summary judgment from Ghislaine Maxwell? Is this it? Is this it? Virginia Guffrey, plaintiff, Maxwell, defendant, counsel for intervening. Motion for Maxwell filed the motion for summary judgment. This is not it. Parties arrived at a settlement jointly discussed. Blah blah blah. Where's my last Google search, you dick? Okay. Unsealed January 2024 by Judge Loretta Prescott of the United States. The documents include testimony and details from a 2008 lawsuit filed by Jane Doe's. How do I find the fucking document? 32F Sup 3D 428. Based on the facts declared, the intervener's motion to intervene is granted, the motion to unseal is denied, and the action is closed. That's not true. How do I fucking find it? The unsealed court documents related to the civil case between are available through case text search plus citator. How the fuck? Case Guffey versus Maxwell 320 sub 3D 428. Parties rather settlement jointly dispute. I don't think that's it. Where's the unredacted motion for summary judgment? Why is this so difficult? I'm just going to end up back here again. 348. 167 documents were sealed pursuant to the sealing order. Why is that so fucking loud? Okay. All right. I'm losing my shit right now. I'm losing my shit. Maxwell, unredacted motion for summary judgment. This is not at all relevant. Okay, I think this is it. It just sucks to read. Jeffrey versus Maxwell, summary judgment, applicable standard, redacted. This is not it. How do I find the exhibits? For the reasons set forth in the summary judgment is denied. This is the response to the motion for summary judgment. This isn't the motion for summary judgment. Unless... Okay, someone tell me what to think. The unredacted memo in support of Ghislaine Maxwell's request for summary judgment. Epstein was a multimillionaire, blah, blah, blah. Okay. Why is it just a podcast? Second Circuit clarifies standards for unsealing documents. Documents have been released from the defamation suit against his ex-girlfriend. Alleged court documents. Jeffrey then sued. Maxwell motioned. Why are they linking to the Daily Beast? Link to the motion, you assholes. Was settled. Include a photo. A 2005 Amazon receipt for order Epstein placed for books about sadomasochism and how to use sex slaves with the titles SM-101, Realistic Introduction, Slavecraft, Roadmaps for Erotic Servitude, and Training with Miss Abernathy, a workbook for erotic slaves and their owners. What the fuck? Yeah. Unsealed flight logs, private jet, list of belonging to Epstein list President Donald Trump. Glenn and Ava Dubin. More unsealed flight records show former U.S. Senator and NASA astronaut John Glenn once flew in a private jet belonging to Epstein along with a Harvard lawyer, Alan Dershowitz, and Epstein himself. Dershowitz told Insider the flight was to L Brand CEO Leslie Wexner's 59th birthday party in Ohio. Wow. Where do you get your news from? Because there is no link. Motherfucker. Why? I'll ask ChatGPT. I'll give you $100 if you can find me a direct link to the now unsealed, unredacted, original motion requesting summary judgment from Maxwell in the case Giuffre versus Maxwell. Oh, please, God. Please. This is plaintiff's response to defendant's motion for summary judgment. I saw this already. This is not the motion for summary judgment. This isn't it. The flight logs, the photographs, and is there an appendix here? What's this? Important messages. Virginia Roberts, all Miss Maxwell. Is this it? Is this what people were talking about? Is this the thing? January 2017, I actually found the foregoing. Blah, 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 blah. Okay. All right. Oh, I feel like I've hit a wall where there's some tool that people use to find the particular motion PDF that I just don't have access to. And so that's it. It's done. But Jesus Christ. All right. That's it.